I'm going to be recording, and this is being recorded. As we were first having discussions on what to present, we decided we wanted to have some kind of a panel discussion about patent litigation, some ideas about the various jurisdictions that you might find yourself in, and then basically questions clients might have and how you go about addressing them. And once we realized we wanted to have a panel, we did a very quick not it, and these guys were on mute. And so here I introduce you now to your panelists, Dan Kent, John Harbin, and Rich Miller. Dan is a partner at Kent & Risley with more than 30 years of litigation and trial experience with some of the most highly respected intellectual property firms in the world, including Fish & Richardson, Jones Day, and Alston & Bird. He successfully tried intellectual property cases in multiple jurisdictions and is regularly asked to speak about intellectual property topics relevant to lawyers and business leaders. John Harbin is a partner at Munich, Carlin & Kerfman. He's a renowned trial attorney with 3 decades of experience in intellectual property and complex business cases, with more than 30 jury and bench trials in jurisdictions throughout the country, in the ITC, and with arbitrations. He tries cases with a wide range of technologies, including computer and hardware and software, telecommunications, aerospace technology, industrial equipment and processes, and biotechnology. He's litigated patent, trade secret, licensing, copyright, and trademark trade dress disputes, and is well known throughout the U.S. as a formidable talent in the courtroom. And finally, Rich Miller. He's a partner at Ballard Spahr, where he's the practice leader of Ballard Spahr's intellectual property litigation group. He's represented both plaintiffs and defendants in patent infringement cases involving a wide variety of technologies in a multitude of district courts, including the Eastern Western District of Texas and the District of Delaware. He's also taken cases through trial in the ITC and has argued appeals before the U.S. Court of Appeals for the Federal Circuit. He's also the current treasurer of the Atlanta IP and of Court and has a master's in barbecue degree.
So pay your dues. So pay your dues.
So and they're going to be talking about patent litigation, advising clients, and some of the preconceptions about some of the jurisdictions you might find yourself in, and some fascinating discussions about some statistics that we dug up for this talk. So just to set things up, we have a scenario. The client owns a patent that claims a groundbreaking method for processing online payments. Client thinks that Big Ash Box Store uses this method and would like to sue them. Big Ash Box Store has physical stores in every state, but the IT employees that manage all aspects of its online presence are located exclusively in San Jose, California. And before we get into just to kick off some of the discussion, we wanted to start with a poll. If you were presented with this situation, where would you advise your client to file suit? The Eastern District of Texas, the Western District of Texas, District of Delaware, Southern District of California, or the District of Puerto Rico? Okay, well, so it looks like most folks picked Texas, but actually, no, it was, well, pretty roughly split between either somewhere in Texas, maybe Delaware, followed by the Southern District of California, and few people wanted to go to Puerto Rico. And so here are some of the statistics that we dug up about it. Top courts by number of cases or parties. On the left, you have the number of cases filed in particular courts, and on the right, you've got the number of parties that are in those courts. And I will now turn it over to the panelists for the discussion.
Yeah, I think I was going to kick this one off. I think I'm on this panel because I'm the designated representative of folks who represent mainly plaintiffs in patent litigation. So I'll be sort of taking that perspective, even though we also represent defendants on occasion. We do, to be fair. represent plaintiffs and patent owners primarily. So from that perspective, my first conversation with the client is going to deal with what is your goal here? What are you trying to accomplish? Because it may differ, the venue choice may differ depending on whether you're just trying to engage in an early stage licensing program, or whether you're near the end of that licensing program, or whether you're trying to enjoin a competitor. And until we really know the answers to those questions, we don't really know exactly what the right venue might be. Now, since TC Heartland, we've got to take a look pretty carefully at what the venue options are. There may not be any, frankly, and if that's the case, then that's a very short discussion. But if there are some options, you need to look pretty carefully at what those options are, what your chances of making them stick are, and do that in light of what it is your client is trying to accomplish. So until you know that, I can't really answer the question because I don't know enough facts. The one thing I do know is that if there's any way to avoid the Northern District of California as a patent owner, you should, because that is, as we like to say in our shop, where patents go to die. We'll see some statistics a little later on that flush that out, but unless you want to put your patent at risk and unless you have no other choice, try to avoid the Northern District of California at all costs.
Yeah, I think from the perspective of somewhat the other side, and I also represent both plaintiffs and defendants in patent cases, but perhaps more often defendants. What this data that we're looking at here reflects is where plaintiffs are choosing to go more often than not in their patent cases. And so as a defendant, sometimes you have a chance to perhaps dictate or at least try to get yourself moved somewhere else. And from these numbers alone, you would take that you want to probably not be in the Western District of Texas if that's where the plaintiffs often want to be. There's not going to be uniform advice around that for any defendant, but just as Dan suggested that he wants to be in places where he can make the case stick, one thing you're often looking for is to find a place where you can unstick that case as quickly and hopefully as inexpensively as you possibly can. And we'll be looking at statistics throughout this discussion about some of the ways you can and cannot do that. One point I want to make that will probably jump out to patent litigators as a big surprise is this giant number of filings by party in the Northern District of Illinois. If that surprised anybody, it certainly surprised us when we saw these numbers. And we just want to note that they're basically massively skewed in view of a couple of major cases against as large numbers of importers as does that were more or less does that ended up with default judgments. So the Illinois choice is not representative really of a meaningful number. So just want to point that out.
And real quickly further to that, I saw just before this meeting started that Docket Navigator's weekly report of outcomes listed a Northern District of Illinois case or set of cases by Oakley against a laundry list of defendants with default judgments. And so to your point, that's exactly what's happening according to Docket Navigator as of this week in that thing that came out this afternoon.
And I just wanted to follow up on what Rich said. I also represent both plaintiffs and defendants in patent litigation, but it's a little bit more than half defendants. And I think Rich said there's no one size fits all. You got to look at what the client's concerns are and goals are. If it's a case, is it a case that involves a very important product for the client? Are there significant sales at stake, therefore significant damages at risk? Is the plaintiff a competitor or someone who may be looking for a license? Those kind of things, or is it in the middle of the road? Sometimes, if it is a small case, the defendant client may not care where you are. If it is a medium-sized case, the client's main interest sometimes is just sure that there are no about expenses. So you just got to look at the particulars of the case.
Okay, well, thanks. And moving on now to some of the things that clients might ask. We come up to basically what's the best place to sue? And just you can imagine the client is pushing to sue Big Ash Box Store in Texas because it will thinks it will get them a Big Ash quick win, which leads us to our next poll. Assuming venue and jurisdiction are proper in any district court, is Texas the best place for a client to get a win? Yes or no? All right, well, it looks like, so 67% say yes, go to Texas. And 33% have said no, not necessarily the best place to win. So I will now turn it over to the panelists along with this outcome comparison in top courts 2016 to present of the patentee versus patent challenger, which basically shows outcomes where the patentee is won in blue, mixed outcomes in yellow, and the patent challenger won in red. And I think I'll turn it over to Dan first of all again.
Yeah, this graphic is just depressing for anybody who represents patent owners and inventors and folks who are on the plaintiff side of the V in patent litigation, because there's an awful lot of red on this chart, and the only place there's much blue is in Illinois, and we've just talked about why that is a little bit skewed. Fortunately, though, the sample size is relatively small. If you look at the numbers under the percentages in each bar, you'll see that we're not talking about a lot of cases over this timeline. Of the many, many thousands of cases that were filed during this time, we're only talking about a very small sample size. So that's about the only encouraging thing that I see in this particular chart. But I think the answer to the question, though, really comes down again to what does a win look like? You know, and if a win is getting a reasonable license fee from one of a number of potential licensees, then that strategy might bode well in a jurisdiction that moves relatively quickly, and that you don't have a substantial risk of the other side filing a motion to transfer right away. You know, sometimes it's helpful to just put the venue fight and take that venue fight off the table so you're not dealing with it. Whereas on the other hand, if what you're looking for is an injunction, then you need to weigh, well, how quickly do I need the injunction? And do I really want a venue fight here before I can get to that or not? So those are a number of factors you need to look at. And I just don't think there's an easy answer. Now, in the hypothetical, we were saying venue could be proper anywhere, but that begs the question that we're going to get to later. Well, it may be proper, but is it convenient, and can you make it stick? And that's really the question for down the road. So the question was purposefully drafted to be overly simplified, but you know, I think you got to know a lot more information before you can make a recommendation for the proper venue.
And to follow up on what Dan said, there's a lot of red, and you know, about Texas in particular, for those who litigate a lot in the Eastern District, you know, local counsel there's, you know, 3 or 4 firms that do a lot of the local counsel work. And they have been saying for a couple of years, you know, it's really not as bad for defendants as far as chances of getting a defense verdict as people think. And that these statistics bear that out, showing that 69% of cases, just going back to 2016, are an outright win for the patent challenger, and another, you know, 1/5 are mixed outcomes, which can mean a lot. So That is noteworthy. The Western District of Texas is surprising with how few cases, 7% only are wins, outright wins, but this does predate the time that, Judge Albright started a patent-centric, practice there. So I think those numbers may have changed somewhat, but if you focus just on the last couple of years, that's pretty notable to me.
Yeah, agreed. I think it's very interesting when you look at, just jumping right on to John's point, when you look at the fact that there are only 115 outcomes in Western District of Texas, and there were 2,000 cases there filed over the last 2 years. That tells you what's really happening here is that cases aren't going to trial in the Western District of Texas, and when they do, defendants are winning, and that's great. But I think many times, if you are getting to trial, that's not where you want to be anyways as a defendant. I think notable here is the win rate, particularly in Delaware, which has a much larger number of cases over this 6-year period going to a final decision of some kind than East Texas or West Texas. Suggesting that plaintiffs can get the case to trial more often and can win more often. So although Delaware may seem like a place you want to be, a business friendly kind of place, it's actually a little bit more dangerous for a defendant than you might hope. And also I want to point out Southern District of Florida with a surprising number of plaintiff wins, and also Miami. So it would, if you're thinking about where you want to be, that'd be pretty cool too.
Well, and of course, another thing that the parties are, especially plaintiffs, are often worried about is what kind of damages you're able to get. And so we also found this outcome comparison with respect to money damages from 2008 to 2021 with some of the major patent courts. And I'll turn it now over to the panel to discuss some of these.
Yeah, these stats are strange to me because they need to be limited by definition, I suppose, to judgments, and maybe they include verdicts as well. So they're skewed in that they don't include any sort of settlement or anything else. They're just looking at a limited subset of things. But from the plaintiff's perspective, what I like to look for is where am I going to get a fair shake? Where is the judge going to give me at least a hearing on this? Where is the judge going to not despise patents and want to get rid of the case or stay it as quickly as possible? And where is the jury going to at least be willing to listen to a reasonable royalty damages theory that may or may not get to a large number? There are some districts around the country where large numbers are just hard to get, no matter what the facts are. I tried a case in a district outside of the Atlanta area one time, and my local counsel said, well, you can't ask for that number. That's more than these folks have ever heard of. And you can't ask for that number. You're not going to get it. And compare that with a place like East Texas that has a history of large verdicts from other types of cases. They were big in the old silicosis and other injury cases arising from the refinery business and the oil drilling business. So they're used to seeing large numbers come out of juries, and that's not a problem for them. So that explains, I think, some of what you're seeing there in East Texas is that it's just there's not a governor on the range of the verdict. So really what I'm looking for from the plaintiff side is someplace I'm going to get a fair shake, not have other sorts of things that act as governor on the damages, and at least somebody willing to listen and hear me out on those sorts of issues. But at the end of the day, it depends again on what the client wants. If what the client wants is a reasonable, fairly early royalty settlement, then the jury issue is less important. And there are a lot of ways you can lose a patent case before you ever get to a jury. So this is a consideration, but in my view, not an overriding one.
And to me, thinking about it from the defendant's perspective, this is the other side of the coin from the fact that you have a good chance of winning outright in Texas. The flip side is if there is a plaintiff's verdict, anecdotally, the Eastern District of Texas, is known for having a supermajority of the super large 9-figure verdicts. And this would support that with the number over 1 million, which will have a comment about the metric, the dividing line that shows. It's got to indicate some larger verdicts and a great number of them. So, I mean, that is a concern when you are, when you're representing a defendant. As Dan said, there's a history in the Eastern District of large tort verdicts, and actually the patent, it becoming a patent rocket docket with patent rules was started when Texas enacted pretty severe tort reform. And the plaintiff's bar said, what can we look to, to keep litigation going here in the Eastern District, and they settled on patent litigation. I think the Western District has very few numbers, but it's almost so small a number that it's hard to draw any conclusion from. It's a little bit interesting. It's that small to me, and it does go back to 2008. But it's kind of hard to draw conclusions from that small sample. Rich, you want to add anything?
Yeah, I think what I think is both interesting and not interesting about these numbers is one, first of all, these numbers are somewhat hard to come by, and so we're taking them from sources we're able to get our hands on, and drawing a dividing line of $1 million as suggestive of whether it's it's a big or a small verdict. I think it's not really all that useful. I'm confident that Dan would agree with me that if he went to trial and got 1.1 million all the way to trial on a patent case, he probably wouldn't be all that happy with the result there. You never know.
Depends on the fee agreement.
Yeah, absolutely. So what I think is interesting about this is you can draw some conclusions about the percentage or the frequency of enhancements from these two pieces of data together, and you can see that, or you can take from it that, for example, while East Texas gives more large verdicts than any other jurisdiction, they enhance most likely fewer of the large verdicts than other districts do, whereas they do more enhancement on the smaller verdicts. So one of the things you always have to be thinking about as you're deciding how much you need to worry about a particular jurisdiction is what is that court's likely, basically what are the chances that if there is a finding of willful infringement, the court will enhance damages, and by how much? So while we see a fairly large percentage of some of these large verdicts getting enhanced, for example, in the Central District of California, nearly almost half, if you're willing to draw the conclusions that you kind of can from this data, it's a much smaller number in East Texas. So something to think about that potentially takes both fees and treble damages off the table, or makes them less likely in those jurisdictions.
And related to that issue, I mean, you always need to calm clients down about the headlines they read concerning patent verdicts, because there's a long way from the headline to the trust account. And it usually goes to the federal circuit, and they have a red pen they are not afraid to use to cut down any large judgment that may or may not be imposed. So that's something that you need to sometimes temper your client's expectations a bit when it comes to these sorts of things.
Dan, is it fair to say that the Central District of California numbers here don't make you any more likely to want to be in California?
Well, I mean, to be fair, the Central District, in my view, is a little more fair to patent owners than the Northern District is. But be that as it may, there's still a lot of ways to lose a patent case before you ever get there. You know, the expectation on a 101 motion in those two districts in California is pretty low from a patent owner's perspective. The risk of a stay pending an IPR is pretty high from a patent owner's perspective. And we're going to look in a bit at time to trial and time to summary judgment, both of which are not favorable to patent owners. So there's a lot of reasons, in my view, to not be out there. Not to mention the fact that they have an annoying line numbering system on the left of their pages, that I just find impossible to deal with, but that's another issue.
Fair enough. So of course, you know, money damages aren't necessarily the most important thing to clients. A lot of them are also interested in injunctive relief, and in particular, preliminary injunctive relief. And so we've found these stats again on Docket Navigator that compare the grant or the denial rate for preliminary injunctions from 2016 to present. And I'll turn it over again to the panel to talk about some of these numbers.
I think one of the things that's interesting about these numbers, first of all, I think you have to set your lens right for these numbers. I think those of us who practice patent litigation know that preliminary injunctions are pretty hard to get generally anyways, and nearly impossible to get for non-practicing entities, at least, you know, over this time period that we're looking at here from 2016 to the present. So I think we, the panel, have decided that one of the presumptions we make about these motions is that these are probably all made in competitor cases, or a huge proportion of them, and are probably all also meritorious motions, that there is a real basis for a preliminary injunction in these cases. So you don't see a lot of people throwing PI motions at the wall that aren't going to have much of a chance. So we're making that assumption about this. And now through the lens of these are a large proportion of these are probably strong motions. When you look at the grant rate, it suggests how difficult it really is to get a preliminary injunction. We're going to throw out Northern District of Illinois because that's massively skewed by default judgments. So we're not looking at that. But now, if you're a patent owner, and now you're, in this case, probably a practicing entity because you're making a PI motion, you're suddenly thinking, East Texas or West Texas might be a place that I would want to be. I can put some legitimate pressure on to get a PI. And on the other hand, if you're on the defense side, which is the perspective I'm supposed to be talking from, getting yourself back into a likely place for you to be a defendant, Delaware, really reduces the likelihood that you are going to find yourself on the wrong end of a PI, and allows you to breathe a little easier if one is coming.
Yeah, this chart also strikes me as overstating the success rate in terms of a percentage, because if you look at the numbers, the raw numbers, District Court of Delaware, 13 preliminary injunctions in the last 6 years. That's not a big number at all. And I agree with Rich 100% that these are self-selected cases. Nobody just files a PI motion anymore. That would be crazy. So these are ones where people have decided it's worth the time and effort to file a motion. Maybe I've got a shot, but if you look at these numbers, it's a long shot at best. And so this sort of statistic and this sort of chart might be useful to talk a client off the ledge when it comes to them really wanting a preliminary injunction, because even if you're in a competitor situation, chances are fairly good you're not going to win. And if you don't win, how does that set up the rest of the case for success or not? You got to think about those things up front.
Yeah, just briefly to add to that, I mean, you could say that chances are better in Eastern District of Texas, but the overall, I mean, there's almost 3 times as many preliminary injunctions motions filed in Delaware during this 5-year period as there were apparently in Eastern District of Texas. So that was surprising to me.
Okay. So, yeah, so having started with some of the things that drive plaintiffs, basically money damages and the possibility of injunctive relief, then there's also the flip side, of course, which is, am I risking the patent? And so, imagining the scenario where the client worries that they might lose their patent because the courts can't figure out the invalidity analysis under 35 USC 101. Is this a problem in all district courts, or are some better or worse than others? So just a quick primer on Section 101 ineligibility. Basically, the courts determined this according to the Supreme Court's decision in Alice. Step one is, are the patent claims at issue directed to a patent ineligible concept? For instance, an abstract idea. Step two is, if so, do the claims as a whole recite an inventive concept or a combination that transforms that patent ineligible concept into a patent eligible invention? And basically, there's been a rise in Section 101 motions, and it's a huge risk for patent owners when they go into a jurisdiction that they're going to get an early Section 101 motion and have a lot of risk to their patent as a result of that. So then from this, we go to our next poll, which is, which district court is most favorable to defendants who raise 101 challenges? Central District of California, Western District of Texas, District of Delaware, Eastern District of Texas, or the Northern District of California. Okay, so it looks like, echoing Dan, most folks think that California is probably a bad place to be if you're the patent owner. And let's turn to, and whereas on the other hand, Texas is probably a nice place to be. So let's see what the numbers say. And I'll turn it over to the panelists. Before I do so, I'll note that it's the same listing of courts on the top and the bottom half of the chart. The first one says the top half has got early stage Section 101 challenges, the bottom half having late stage 101 challenges.
Yeah, so so a lot of the numbers that we've shown you, I think in our view might surprise some of you as to how they come out, win rates, verdict sizes, things like that. This one surprised no one. In fact, we do have this the stats here, the grant rate on challenges to a patent under 35 USC 101 in the early stage. So on a motion to dismiss or on a motion for judgment on the pleadings, granted only 5 times in the Western District of Texas out of 27. Whereas moving over to the Northern District of California, you're looking at more than half of the patents challenged under 101 being invalidated. That's a big number. So if you're a defendant, you're representing a tech company, and you've been hauled into West Texas, your goal, if your home is Silicon Valley, your goal is to try to go home if you can, and increase your odds of at least putting some real pressure on the plaintiff, if not flat out ending the case early. But there's one other thing I want to note about these numbers before I give up the mic, is that if we look at the West Texas numbers, there have been a total of 32 motions for early determination under 101 since 2009. Now, the fact of the matter is, this reflects training. This is because Judge Albright essentially trained defendants that he is not going to grant these motions, don't bring them. And defendants have responded. They aren't raised all that often. And that's an very important consideration, I think, for both plaintiffs and defendants as you're thinking about your jurisdiction.
And this stat is, again, illustrative of what I was saying earlier about why the Northern District of California is such a bad venue for patent owners, because the judges there apparently think that more than half the patents granted by the patent office should never have been granted. That's astonishing to me. And I hope it's astonishing to all the patent practitioners in this meeting, because basically what this is saying is that half the time you're doing lousy work or the patent office is doing lousy work. And this particular problem, this 101 problem, has substantially skewed patent litigation and patent licensing and patent value, frankly, ever since the Alice decision came out. What now, 7 years ago now, almost 8. And this is a big problem. Now, the trouble with predicting what the outcome is going to be in a particular venue is, other than the Western District of Texas, you don't know exactly which judge you're going to get. In Delaware, there are some judges that are loath to grant early 101 motions and others that are happy to. And you don't really know who you're going to get until you get it. So, this is a tough one, because I've not been able to find much useful information other than the level we're looking at here on this chart to help you predict, how a 101 motion may or may not shake out. But I do know this, as I said before, Northern California is not where you want to be if you want to have a patent left after the end of your litigation, because you got a 50-50 shot at best of surviving at one point or another. Because remember, keep in mind that as a plaintiff, you have to defeat not only the early 101 motion, you also have to defeat the later 101 motion. It's usually part of your summary judgment papers that you've got to defend. So, it's 2 hurdles, not just one. For a defendant can just win one or the other, but the plaintiff has to win both.
Does anyone on the panel want to talk about this? Something you said something interesting, Dan, which is that you know what judge you're going to get if you're in the Western District of Texas. Just for those that might not be aware, why is that?
Well, because if you file in the Western District of Texas, Waco division, there's only one judge. The Eastern District of Texas used to have something similar, but they have recently changed that. So if you file in, I think it's Marshall, it's not 100% chance you're going to get Judge Gilstrap anymore. They've now shifted things around, and I believe they've published fairly recently what your percentage chances are of getting a particular judge if you file in a particular division of that court. But for the moment, at least in Waco, the Waco division of the Western District, there's only one option. And there are courts around the country that are similar to that, but most of those courts don't have a lot of patent litigation. So, sometimes you can tell and sometimes you can't. If you go to the Southern District of New York, for example, there's, I forget how many, 50 judges in that district, but they do have a judge or two that sort of focus on patent cases. So you might get that judge. It's hard to predict. So does that answer your question, Alan?
I think so. Yep. Thank you. And so the next, so moving on now, kind of also keeping with the theme of stages of a case and timing, another consideration for clients is how fast do I want to go? A lot of times a client will want to know if it's better to pick a rocket docket for their case, which leads us to our next polling question. On average, how much longer does it take for a patent case to get to trial in the District of Delaware than it does in the Western District of Texas? Answer A, 2 times as long. Answer B, 3 times as long. C, 4 times. And D, 5 times as long. Okay, well, it looks like most folks thought 2 or 3 times as long to get the trial in Delaware. than it would in the Western District of Texas. And when we looked at the statistics, it was actually, this was kind of one of the more surprising ones. Here we've charted out some various patent courts, some of the top patent courts' average time to trial, which is in the big bars from 2019 to 2021. And listed here is 2019, 20, and 2021. And then for the 2021 year, we also put the average time to claim construction. And I'll just turn it over to the panelists. Was any of this surprising?
I'll take this one. It wasn't all that surprising to me, except for Northern California, where the time to claim construction and the time to trial appear nearly identical. We're trying to figure out what that meant exactly, and maybe it just means they're slow in getting their claim construction orders out. I don't know. That one's a little strange to me, and maybe it's just the way the data are skewed. But you know, time to trial is one issue, but time to other events is also an issue from a plaintiff's perspective. The sooner you can get the defendant to have to do work and focus on the case, whether it be claim construction or discovery or contentions or whatever it is, the sooner you can have a reasonable conversation with that party about whether they want to take a license or keep fighting, if that's what your client's goal is. Obviously, that's out the window if what your client really wants is an injunction. But if what your client wants is a license, then you know the sooner you get to the defendant doing work, the better off you are.
And this shows it's kind of a trick question because the Eastern District of Texas is actually longer than Delaware. 2021 and getting to trial, it's gone from a little over 2 years to going on 3.5 years, over 2 years in 2019 to 3.5 2021, because they've just got so many cases, literally hundreds of cases. There are a couple of jurisdictions in the country, if you're interested in a rocket docket, that are still 2 rocket dockets. We recently, on the plaintiff side, filed a case in the Eastern District of Virginia, and COVID caused the judge to delay the trial twice because of having to try criminal cases after resuming trials. But it looks like we'll still have a trial within 2 years of the filing date. So, but none of the traditional jurisdictions are really rocket dockets anymore, focusing on the time of trial.
And then also, you know, kind of in the mix of time to trial, of course, the client's also got to be worried about, is there any way this thing can get held up because of the defendant? And of course, that leads us to our next poll. On average, how much more likely are motions to stay pending IPR review granted in the District of Delaware than in the Western District of Texas? Is it 2 times more likely to be granted in Delaware, 3 times more likely, 4 times, or 5 times? Okay, so here it looks like most folks thought it was either 2 or 3 times more likely to get a motion for stay pending IPR review and granted in Delaware than it would be in Texas. And I think that was what we kind of originally thought too. But when we looked at the statistics, again, it was slightly surprising. Delaware and Texas seemed, you know, especially Delaware and the Western District of Texas seemed kind of more similar, and the Eastern District of Texas even had a lower rate than Delaware is. And I'll turn these stats over to the panel.
Yeah, these are kind of among the more important things to keep in mind as a plaintiff, because a stay pending an IPR is death to any sort of licensing program. And you know, this is something where you really need to keep your eye on the ball and make sure that you don't create a situation for yourself where your patent program is dead before it ever really gets started. So, this again suggests to me that Eastern Texas is a better venue than Northern California, for example. But, nothing new for me on that score.
I just have a couple of comments. I mean, it is, I agree with what Dan said, and I think one thing that's helped in Texas is the longer times to trial. You don't really have a chance of getting a stay until trial is instituted. But now you've got a chance, if you act diligently, you can get trial instituted before the case is too close to trial, given the longer times to trial. So you have a better chance of getting case stayed. Rich, you want to add anything?
Yeah, I actually think, Alan, can you move to the next slide and show that was a 10-year statistic. And I think what's interesting is we've broken this down into pre and post Judge Albright, and not to be, nobody here we're not picking on Judge Albright at all. But he has been in the news quite a bit lately, and his court is interesting and doing interesting things. One of the things I think will surprise people who are, who kind of just read the Law 360 headlines when they come by, is that the grant rate for motions to stay pending IPRs in West Texas under Judge Albright is 50-50. Similar, very similar essentially to the Central District of California or the District of Delaware, whereas the East Texas numbers probably line up with what you were thinking. But once again, we need to look at the total numbers here, right? For the Western District of Texas, there's a total of 14 motions to stay pending IPR over the course of 1,000 patent cases filed there a year, roughly. So once again, this reflects training, that these motions get denied quite a bit, or Albright's practice was for some time just to sit on the decision until he got real close to trial and then deny it at the verge of trial. There was a relatively high profile battle on a mandamus petition in the federal circuit about exactly that practice, and things have changed a little bit, but still the likelihood in the end that you're going to get a stay is, from the defense side, incredibly important, because it's a very powerful tool for a defendant, and you'd like to find yourself somewhere where you've got a good chance of getting one. And so trying to move out of East Texas or out of West Texas, notwithstanding the raw percentages there, is what you're going for.
Okay, well, so having kind of addressed the risks of the patent and also some of the benefits to the patent holder, we move on to probably, the question of where can you sue somebody? What about venue? And so the question here is, remember, Big Ash Box Store has physical stores in every state, but the IT employees that manage all aspects of its online presence are located exclusively in San Jose, California. Since client's patent is a method that involves the online processing of Big Bash Store's business, that was hard, Big Bash Box Store's business, the client is concerned about losing a venue motion if it sues in the Western District of Texas like it would like to. So just a brief primer on venue motions. Two ways these can come up can be with a Section 1400 B motion to dismiss, basically saying that venue is not proper at all in this, where I have been sued now. And there also can be a motion to transfer under 1404A, saying, well, maybe you can get venue here, but really everybody that I want to be in this case, or that you're going to want to ask about this case and interview, and all the evidence and witnesses is located somewhere else. And so it really should be tried there and not where I've been sued in Texas. So this now leads to our next poll, which is in the Western District of Texas. What is the likelihood of winning a 12B3 motion to dismiss for improper venue? 10%, 25%, 50%, or abandon all hope ye who enter there? So it looks like most folks thought it was somewhere around an abandon all hope or a 10% chance is probably most likely. And some lesser numbers thought that it was even up to a 50% chance. And then just to follow this one up real quick, like we decided to ask another poll, similar question in the Western District of Texas, what is the likelihood of winning a motion to transfer under section 1404 to a more convenient venue? Here the answers are 10%, 25%, 50%, or you're not going anywhere, cowboy. All right, so pretty much similar to what we saw for the poll about the motion likelihood of winning a motion to dismiss. And so with that, I'll turn to some of the statistics we've got. First, we had for the motion to dismiss for improper venue. This is pre-TC Heartland and post-TC Heartland for some patent-heavy districts. And I'll turn it over to the panelists.
Yeah, so for those who don't follow patent litigation, TC Heartland is the case that changed the way that the patent venue statute is understood, and essentially changed the locations where you could bring a patent suit to the place where the defendant resides, which was interpreted as the place of incorporation, or where they have a regular and established place of business, which that standard was then subsequently interpreted to mean a physical place of business where there are employees or agents carrying on the business of the defendant. So that's the requirements, and you can see that these motions were almost never made before TC Heartland. Now they're starting to pick up. What's interesting about 1400 is it's not really a discretionary thing, whereas a transfer under 1404, which we'll talk about in a second, is a little bit more discretionary. Here, this is this is done on a motion to dismiss for improper venue, and if you can establish that you don't have a physical location in the jurisdiction, you can get out. The question has become, what is a physical location of the defendant? And this is a place that allows on the defense side a little bit of strategy if you can do it, perhaps on the front end. There are cases that talk about ways that you can structure your business, perhaps with subsidiaries or through franchise-like arrangements to have your physical presence in a perhaps patent unfriendly jurisdiction to patent defendants be someone else. And then the question becomes there, how much control do you exert over that someone else? And there have been a number of cases lately where some corporate structures can be used to protect you. We can go into it. It gets a little bit detailed. We're almost out of time, so I'm gonna just stop right there on that. But there's some interesting stuff.
Yeah, and in the interest of time, I think I'm just going to focus on kind of the bigger picture issue here. And that is, if you understand, as we talked about at the beginning, if you understand what your client's goal is, then you can decide whether you want to waste your client's time and money, and sometimes your client's time and money, fighting a venue battle, because it takes a lot of time. It can take 6 months to sometimes a year to fight that battle. And during that entire time, you're likely not having a productive conversation with the other side about a resolution of the case. If your only alternative is the Northern District of California, then maybe in that situation, it might be worth the time and money to fight that battle. Because if you go to California, you only got a 50-50 shot of preserving your patent. But if you have other alternatives, maybe you think about that, and you don't want to waste the time and money on a venue battle or other preliminary things. Now, one question real quick that came up in the chat, and thanks Warren Thomas for this one, was an observation that really that the Northern California position is interesting because that's where high-tech businesses are located. Why is that? Well, I don't know. My suspicion is that the judges in the Northern District of California have largely worked with large firms or firms that have relationships with big tech companies. And big tech companies generally, while they get patents, I think they tend to have a a view of patent holders that are not big tech companies that is, say, less than favorable. So unless you're a big tech company asserting a patent, you're, in my view, not going to get as fair a shake as you would if you were a big tech company. That's just my outside view. It's a little bit cynical, I admit, but that's what it looks like to me. So.
I think if we look at the transfer numbers, just to wrap this up, because so a dismissing for improper venue is one thing, and but as Dan said, a transfer, a battle over transfer is theoretically available to anyone. Whether or not you can win is a different question. And perhaps the most highly publicized battles that we've had over the last 6 months or a year have been between Judge Albright in the Western District of Texas and the Federal Circuit over denials of transfer motions. And so one of the things we wanted to put up here are some of the statistics of the likelihood of getting out on a transfer motion. It's you can see that lots of defendants want to try to get out, and the grant rate should probably be surprising folks, right? That it looks like Albright is granting transfers out at a clip of almost 45%. That's a little bit skewed. A number of those grants were, in fact, as a result of a mandamus order from the Federal Circuit. A number of them are inter-district transfers. He frequently will transfer a case from Waco to Austin to himself, where he also sits. And then in certain cases, they are actual transfers out, but the percentages are lower than are indicated here. But nevertheless, you can see that by just the fairly large number of decisions on this, defendants are trying to get out of the Western District of Texas, and it's for the reasons that that we talked about earlier of trying to make a case a little less sticky.
Okay, and then to wrap things up with the final question for the panel about what about the home court advantage? Is it better for the defendant to be able to be in their backyard? Is it better for a plaintiff to maybe get some advantage by suing where they are or in Texas? And I'll open that up to the panel.
Yeah, so just real briefly, and the home court advantage for plaintiff is largely gone thanks to TC Heartland, unless your defendant is also in the same jurisdiction as you. But you can flip that around, and if you're willing to take whatever risk is associated with that venue, and you sue the other side in a place where they really can't move to dismiss or transfer, it's a bit of a show of strength, and it gets you to the merits more quickly. So that's something you got to weigh when you look at the nature of the claims and you look at the nature of the patent program you're running for the client. But it's something to think about, and sometimes works.
And from the defense perspective, I think it depends on the defendant, but I think it's a general rule. Clients I represented, yes, we do a lot of litigation nationally for a major consumer products company, and they're always very comfortable to have the case be where the business is, because they generally they and their products have good reputations. I did have one client who had a good reputation, but they were actually a little worried about it being transferred to the home jurisdiction because they felt their judge may bend over backwards to avoid showing favoritism to them to favor the other side. But that's a little unusual. I think we're out of time though. So thanks, Dan, Rich, and Alan, and we hope, thanks to everyone who listened. We hope you enjoyed it. Alan or someone else, Jason, I don't know if y'all have a sign off or anything to say at the end.
So yeah, I think we're going to move into the social session. And I'm sorry, I just cut somebody off.
No, I was just going to say the same thing. I was going to say, thank you so much. We're going to move into the social. If you don't want to join, I'm going to give you 2 minutes to get off, and then I'm going to start assigning breakout rooms.
Sounds great. And huge thanks to our panelists. Great job today. We really appreciate it, and hope to see you in the social session.